Good morning.
Good morning.
Thank you for everything that you provided to us. We have had a good opportunity to read what you have sent. And at the moment, our view is that the central issues here are the settlement, Article 12 ground, and the discretion. So if you would concentrate on that to start with, I think that would help us.
Absolutely. If I may say so, we took the same view.
Thank you.
The appellant. Myself and Mr. Crossthwaite appear on behalf of the appellant mother. The appellant mother is attending the hearing remotely. My learned friends, Mr. Gupta of King's Counsel, together with Miss Morton, are present in court, and Miss Gaunt is appearing remotely.
I gave permission for that.
Yes, thank you.
And the respondent father is present in court. As you are aware, this is an appeal against the judgment of Mr. Allen of King's Counsel, granting an order of summary return and dismissing the appellant's case that defence under Article 12 settlement and Article 13b was established. Thank you for confirming that the court has all the documents, including what is now, for all intents and purposes, an agreed note of the hearing. There's one tiny passage that is not agreed. It is what it is. It's unfortunate that we don't have a transcript. We thought it was right that the matter was flagged with the court yesterday, but we don't press the court to adjourn this hearing for the receipt of a transcript. If I may start with the appellant's court case in respect of grounds 1 and 2 with regards to settlements. It's asserted that although the judge identified the correct legal principles, he misapplied them in a flawed and overly technical approach to the gateway requirement, the Article 2012 defence, which is to ask the straightforward question whether the child who will endeavour to refer to as X was settled in this jurisdiction at the relevant date. If the answer is yes, the court then moves on to the discretionary stage. If the answer is no, there is no defence, and the court is obliged to make an order or return.
Now, can I just ask one thing? The relevant date, the phrase you used there. Are you agreed between you that in this case, it doesn't matter whether the relevant date is the date on which the proceedings were started or the date of the hearing, or is there an issue which this court would have to resolve?
That was the position adopted by the appellant and the respondent at the trial, that it did not make a material difference. The only point of detail I should emphasise here is that it's featured through the judgment that the child is said to have only started nursery after the father issued his Hague Convention application. That's not in fact correct. It had been said clearly in the mother's skeleton that the child had attended 2 nurseries, and in fact the child was enrolled in the first nursery in early 2023. So
the reason I raise that point, Ms. Guha, as you will appreciate, is there's now a conflict, unfortunately, of decisions at first instance.
yes.
Well, there always was, but there's now, as it were, a heightened conflict because Mr. Justice Harrison has come down on Mr. Justice Mostyn's side,
Yes.
as it were.
Yes.
And it seems to me that if this court did have to resolve that, that would involve an extensive analysis, not just of the authorities of this jurisdiction, but worldwide. And for my part, I find that an unattractive prospect if it's not an issue in the case. You haven't argued it.
No, I mean, we rely upon the judge's analysis, which was consistent with the appellant's position, which is the relevant date is in fact the date of hearing. So it was not a point of challenge for the appellant.
Is that right, Mr. Gupta?
There's no issue on this particular case. Your Lordship and my lady don't need to deal with that point in this particular matter.
Thank you.
Thank you.
And also, you were saying that your position obviously is that the judge identified various principles that then misapplied them in the circumstances. But your position also is, as I understand it, that he ought to have taken a holistic approach in relation to all the matters, but then it was for him to evaluate those matters when deciding on settlement.
Yes, and we say that the judge did not undertake a balanced consideration of both the father's and the mother's case, and it is due to the flaws in his approach that has led to the rationally insupportable conclusion that, firstly, the child was not settled at the relevant date, and secondly, that the discretion should be exercised to make an order for return. And we submit that the guidance in the jurisprudence is clearly set out, as your ladyship has just identified, that there must be a holistic evaluation of a fairly straightforward question at the gateway stage as to whether the child is settled. And the error that the judge fell into in this case was he adopted an overly technical approach. He introduced a gloss or subtest, and he opened the door to a potential proliferation of issues in settlement cases where, for example, the prospect of oral evidence was being contemplated.
I think it's also part of your case, correct me if I'm wrong, that he put the threshold too high.
Yes, yes.
The word permanent appears in his analysis on a number of occasions. Is that, we'll come on to that, is part of your case.
Yes, yes, it is, absolutely. And in the supplemental bundle, we're coming to it in due course, we've produced the copy of the Court of Appeal decision in a child objections defence in Re-M, and the reason for that was because it was emphasised by the Court of Appeal that when approaching Hague defences, there must be a simple approach and a straightforward construction of the language of the Hague Convention at the gateway stage, which then opens the door to the discretion, but these separate and distinct stages that must not be blurred. If I may briefly address the legal framework, and I did want to take the court to a few cases in the bundle of authorities. If I can start with the at tab 21 in the bundle of authorities, with the explanatory report prepared by Professor Perez Vera. And firstly, if I invite the court to look at paragraph 11 on page 474. And in particular, the second paragraph, I invite the court to read that.
So, sorry, we're on page 474.
Yes, and it's the last paragraph on the right-hand column.
Thank you.
11.
Yes. I would
Do you want us to go over the page as
I
well?
would also invite the court to read that in conjunction with paragraph 25, the first paragraph. Yeah, paragraph 25 on page 478. And also, I'm sorry, I skipped a paragraph, page 476. It's the last paragraph of paragraph 18 in reference to the re-establishment of the status quo.
And this is
Explanatory report prepared at the time of the convention was passed.
Thank you. So in establishing a
It's the
broad,
equivalent of the Lagarde in the United States Convention.
so in establishing a broad and purposive construction of the language of the Hague Convention, this is a critical report that's often referred to. And we can extrapolate from these paragraphs that the primary objective of the Hague Convention is to rectify the harm caused by the removal of the child from its habitual environment or country of habitual residence as the child is taken out of its family social environment in which its life is developed. And the aim of a summary return procedure is to re-establish the status quo as expediently as possible in returning the child to what's referred to as the home country, so that the welfare dispute can be resolved by those courts in looking at the long-term arrangements with the child, any disputes about with whom the child should live and where the child should live. And so the dual objectives are said to be, one is preventative and the second is to secure, and the word is immediate, reintegration of a child into its habitual environment. And as the court will be aware, one of the fundamental tenets of the machinery of the 1980 Hague Convention is that it must progress expediently and swiftly to allow the immediate reintegration of the child into habitual residence. And therefore, it's therefore discernible why the Article 12 defence of settlement was carved out, because in this situation where the child has been away from its habitual environment for more than a year, this militates against the ultimate convention policy of returning the child swiftly to allow the courts in that country to determine the welfare dispute. And just so that I don't go back and forth, a couple of minor points relevant to discretion is at paragraphs 107 and 109 on pages 504 and 505. And the issue flagged in paragraph 107, sorry, this is in fact in relation to the Article 12 defence of settlement, where it was emphasised that after a child has become settled in its new environment, its return should take place only after an examination of the merits of the custody rights exercised over it, something which is outside the scope of the convention. So that brings into sharp focus at the discretionary stage in this case why the court decided that the Portuguese courts were better placed than the Welsh courts.
There's as I understand it, there is a difference of opinion internationally about the extent to which there is a discretion in settlement cases. That passage from the Perez-Ferrer report would suggest that there may not be, but the view that the law we apply in this country is as set out by Baroness Hale in Zimbabwe, is it not?
Yes.
There is a discretion, although the scope for it may be limited. I mean,
yes.
You're going to come on to that.
And I think it was also addressed in Canon, and I think in fact Article 18 of the Hague Convention implies that there is a discretion. Paragraph 109 highlights the potential difficulty at the end of that paragraph if the proof or verification of a child's establishment in a new environment opens up the possibility of longer proceedings than those envisaged in the first paragraph of Article 12. And there's a distinction between the first and second paragraph of Article 12. The first paragraph refers to the return of the child forthwith, but in cases of settlement, it's notable that the word and it only refers to a return order being made. And that again is relevant to the Article 13b defence. If I can now ask the court to look at the case of Re N, which is the classic exposition of the law in relation to the gateway stage at tab 1.
This is Mrs. Justice Bracewell.
Yes, and it's pages 8, bottom of pages 8, going over to page 9. And I would ask the court to read the bottom paragraph of page 8 of the red lines, essentially.
I don't have any red lines.
Oh, I apologise for that. A version was lodged.
So where am I going from? The
Yeah.
last paragraph, the second question.
Yes, up to on page 9, the paragraph starting in the middle, every case must depend on
Yes.
peculiar facts.
Thank you. The dicta of Mrs. Justice Bracewell has been relied upon in all jurisprudence and is good law. It illustrates that it is should be a straightforward test, looking at the physical constitute as to whether the child is established in its community environment, its new environment, and whether the emotional element denoting security and stability is satisfied. And Mr. Justice Bracewell said in respect to the phrase long term that was not defined, but it was the opposite of transient. And that again has been the approach that has been adopted. And there is an important passage at the end of the reference that we've made, which is Mrs. Justice Bracewell said that whether or not the mother herself is settled in the UK is not a relevant factor.
Where you say, where's that? Oh, that's
That's in the
halfway
middle
between
of the
them.
page. And the court emphasised that it was not the welfare test that the court was concerned with applying Article 12, and that of course must be the gateway stage rather than the discretionary stage. And this is because Article 12 is widely referred to as a child-centric defence, where the focus is exclusively on the child and the child's perspective rather than the adult's perspective or their intentions. And the main plank of our challenge to the decision of Mr. Justice Allen was that his focus was misdirected upon the mother, and in terms of, and he was overly technical in his approach in attempting to tease out what the mother may or may not have thought, intended, what her state of mind was at particular points of an extensive chronology over 2.5 years. And we say that this was a skewed approach which eclipsed the straightforward examination as to whether a young child who arrived in Wales at the age of 9 months, lived there for 2.5 years, in the same home, for example, for 2 years, who established roots in terms of a community, friends, family network, whether from her perspective she was settled in the physical sense and also an emotional and psychological sense. And we say that this gateway test does not require a respondent to establish that they intended to remain in the country permanently. And the fact that there were continuing discussions and negotiations between the parties about a prospective return does not militate or prevent a child becoming settled in that country within the terms of Article 12. The next case I'd invite the court to look at is at tab 2, Canon at paragraph 47 on page 27. Sorry, it's paragraph 50 on page 27. And if I could invite the court to read paragraph 50. The first category is said to be where there's a delayed reaction and there may be no misconduct on the part of the respondent. The second category of case is said to be where there's concealment and subterfuge. And the third category of case, paragraph 59, is said to be termed manipulative delay. In looking at all those categories, we say that this falls into the first because there was no finding by Mr. Allen, King's Counsel, that there had been any misconduct by the mother, or as
beyond the potential.
Yes, yes, and therefore, in looking at, and this clearly is not a case where it's the opposite end of the spectrum to one of subterfuge, because the father was fully aware at all times where the child and mother was living. In fact, the mother says he gave their choice to take her home, to enrol the child in a play group and nursery his blessing, because he visited the child and on 33 occasions in a 2.5-year period, and was sometimes travelling twice a month to stay in Wales, to spend time with his daughter, to become familiar with her life in Wales and to integrate himself into that life so that he could maintain a relationship with his daughter. For example, he visited the playgroup, and there's reference to that in the evidence. But what was said in Canon by Lord Justice Thorpe at paragraph 57 is to consider the physical element is to ignore the psychological elements, which in combination comprise a whole child. And a very young child must take its emotional and psychological state in large measure from that of its sole carer. And gave the example that the older child, who is consciously or unconsciously enmeshed in the sole carer's web of deceit and subterfuge, will arguably therefore be less settled. And I can take the court to an example, brief C, where the fact that it was said that the taking parent and the child were effectively fugitives because they were living under assumed names in this jurisdiction for a period of 5 years. And that arguably could lead to an argument that the parent herself was not settled if she was living under an assumed name and on the run. It does not automatically follow that the child themselves is not settled. And we say that is why Mrs. Justice Bracewell drew the distinction that she did. And we say that was the fundamental error that the judge in this case fell into, because he equated the child's settlement with the mother's settlement and in fact made findings as to whether he thought the mother was settled or not. And I will take the court in due course to the judgment to explore that passage.
And he did so, I think, partly on the basis of that phrase at paragraph 57 of Lord Justice Thorpe's judgment in Canon, which is, a very young child must take its emotional and psychological state in large measure from that of its sole carer, and therefore he then went on to concentrate on what he considered to be the position of the mother.
And we say the difficulty there was that in reality, this was a very young child who would have been shielded from any uncertainty which is said to have emanated from the parental disagreement, because their life was moving forward on the ground, and there is not a shred of evidence in this case that the father was asserting that the child was emotionally disturbed in any way, was not progressing in her developmental milestones, was exhibiting any signs of emotional distress. And those were powerful factors which were simply ignored by the judge. And I'll take again the court to the passages of the very detailed statement which was filed by the mother, which over 5 pages explained the intricate details of the routine, the pattern of life that the child had developed in this country. And we say those were the magnetic factors which the court should have been examining, rather than the far more tangential issue in looking at the snapshot of certain messages exchanged between the parties as to what the mother may or may not have been thinking at a particular point in time because of what she was saying to the father.
Paragraph 57 of Lord Justice Thorpe's judgment in Canon is his analysis of a submission made by counsel who had appeared as advocate to the court at first instance, I think, Mr. Nichols.
Yes.
Cited at paragraph 52.
Yes. Yes, that's correct.
And it's in the context of a concealment case.
It is, and I was going to come on to say that an alternative proposition that's been put forward can be seen in the case of AX and CY at paragraph 20, and then that's tab 8.
I didn't mean to take you out of...
But it may be helpful to deal with this in one...
Were you going to take us to re-see it as well?
Well, perhaps I should deal with that first. If I re-see is at tab 3. And this was...
There are 2 re-sees.
Yes. This was a decision of Mr. Justice Kirkwood.
I was wondering whether you were going to take us to Sir Mark Potter.
Well, both of them are relevant, my lord. If I can briefly deal with the decision of Mr. Justice Kirkwood, it's at paragraph 22. If I could ask the court to read paragraphs 22 and 23. So that's an example of what I was referring to earlier, that even in a case where the parent was characterised as a fugitive who was on the run, where the child's relationship with their father had entirely severed and they were having no contact, this did not inhibit the court making a finding of settlement under Article 12. And in the case at tab 4, which is the decision of the former President, Sir Mark Potter, the relevant passages are at paragraph 54 onwards.
It's paragraph 46 as well, isn't it?
Yes. That reiterated the test from Rien.
I'm sorry, so 54, did you?
Yes, it's paragraphs 54, 56, and 58. The background of this case was that there was been a wrongful removal. The father was in the US, did not know where his child was, and did not have any contact for 5 years, tracked the child down eventually through the internet. And there was evidence that the older child, who was school age, had a history of trouble from persistent bullying and emotional disturbance. But despite all of those countervailing factors, the holistic evaluation of the court nonetheless was that the child was settled within the meaning of Article 12. And it's relevant to note at paragraph 58 that the court was very clear that the court in Michigan or Florida was in no noticeably better position than an English court to decide the welfare questions concerning the child, particularly where all the material events in her recent life had taken place in this jurisdiction. And that, of course, is equally applicable here.
I mean, that's not relevant settlement, is it?
No, it is, but
It's by
it's just
discretion.
to say going back and forth, my lord.
Yes, thank you.
If I can then turn to AX and CY, which is at tab 8. The view expressed by Mr. Justice Peel, who was dealing with a 6-year-old subject child, at the bottom of the page,
Which page, I'm sorry?
177, paragraph 20, was that it would be logical to say that to become settled in a new country may be difficult for a 6-year-old.
More difficult for us.
Yes, than it would be for, say, an 18-month-old at the time of removal. And that's a reference decision, actually then was Mr. Justice McCurr in RS and VKS. And again, applying that to the facts of this case, the child at the age of 9 months would have adapted with far greater ease and a child who was integrated in her school, who was in a shared care arrangement on the facts of the case before Mr. Justice Peel. And it's also relevant to look at, there was no comparative evaluation by the judge in this case of what the child's life was in Portugal prior to the move to this country and thereafter, because the chronology is clear that the parties had just started living together when the child was born. By the time she was 8 months in August 2022, they had separated. The mother moved out into temporary and what she says was inappropriate accommodation and was reeling from the breakdown of the relationship. And she says that she was having to confront the abusive experiences she said that she suffered during the relationship. And it was in those circumstances that the mother comes to Wales a month after the separation in September 2022, and she had visited her home environment previously. And she said, on coming here, she realised she needed to stay and ask for more time. And the phrase that was repeated is that she required time to heal. So in those circumstances, it's difficult to understand why the judge did not focus upon the situation for this child in October 2022 in seeing whether they were able to settle with their mother in a familiar home environment. The mother had left Wales in 2019 when she arrived in Portugal, in circumstances where there was no protracted period of separation from her father, and her father quickly visited and was able to maintain a strong relationship in this case. There's been, and in fact, it's recorded within the judgment, it's paragraph 30 of the judgment, that to the credit of these parties, they were able to work very collaboratively, constructively. There was a surprising degree of parental harmony. And that, again, was critical in examining what the child's day-to-day reality was on the ground. What she witnessed was she was shielded from the parental conflict. She saw her parents able to work together. And that, of course, would have been highly material in allowing her to settle. And although the judge refers to that passage and that evidence, paragraph 30 of his judgment, it then does not feed into his actual analysis in looking at the gateway stage. And I then wanted to turn to the case of F and M and N, which is at tab 6. And if I could ask the courts to read paragraph 66 on page 81.
Sorry, at tab 6 I've got
Oh, I apologise, it's my mistake. Tab 5. It's page 66 though, that's correct.
Sorry, what page?
Mr. Justice Black,
Yes.
page 66. What? Sorry.
Page 81, sorry, paragraph 66. No, page
No.
80. Page 80.
Paragraph 66, whatever.
Yeah,
page.
yes, yeah.
which passage in particular do you rely on?
We rely upon the fact that the Court of Appeal has rightly warned against the development of an unduly technical approach to the question of settlement, and this flies in the face of the objective of the Hague Convention and would prevent or counter a speedy resolution of Hague Convention disputes, and the more complexity and sophistication that attaches to the Articles of Convention, the more cumbersome the procedure will become, which will lead to delay and the ultimate objective of swift resolution of these cases not being achieved. And we say that, and I'll come on to look at this, but the judges focus upon parental intention and whether the mother was settled or not, was introducing sub-tests, an overly technical approach, which, as I've already said, would have the undesirable consequence of the prospect of oral evidence from parties being introduced into settlement cases. What's happened traditionally is that oral evidence may or may not be heard from the CAFCAS officer, but it is almost unheard of for the parties themselves to be expected to give evidence in the settlement cases. And I will be taking the court to the most recent Court of Appeal decision in respect of the use of oral evidence in Hague Convention cases. But briefly, if I could refer to the supplemental bundle now, and the two cases of Re-M and Re-B. Re-M is at tab 2, and again this is a decision of Lady Justice Black, which she then was. And I would ask the court to look at paragraphs 11 to 13. Which really reiterates what was said in FM and N. And I'd also ask the court to look at paragraph 50.
That was paragraph 50 and paragraph...
Paragraphs 11 to 13 and 50.
Thank you.
This isn't a settlement case, is it?
No, it's a children's objection defence, but the analogy we draw is, again, there's a gateway stage and a discretion stage. And the Court of Appeal, in this case, reformulated the approach to children's objections, which they said had become overly cumbersome. Sorry, it's not paragraph 50, it's paragraph 63. We say, in respect of the gateway stage in settlement cases, there should be a straightforward examination of whether there's settlement in the same way as objections, and then it's at the gateway, at the discretion stage, the detail of the case and welfare issues should be examined. So what was happening in objection cases was that factors such as whether there'd been undue influence and whether the child was expressing their authentic wishes had crept into the gateway stage. And the court said, actually, that's the wrong approach. This is made now far too complex, and those issues are relevant, but are only relevant at the discretionary stage. And what was said is, at paragraph 66 is that the undesirable consequence of elevating the test too high at the gateway stage is that the majority of cases will not then fulfill that criteria. And that is, in fact, a proper decision at the second stage, and the danger that the court would be entering into was that you would rob the discretionary stage of its value. And those are the comparisons that we wanted to draw with the approach to the settlement case. And if I can move on to the case of Re B, the relevant paragraphs are at 57 and 64 to 66.
And this is oral evidence.
Yes.
Sorry, what page?
It's paragraph 57 and 64 to 66. And we say that's the inevitable consequence of the subtest introduced by the judge in this case. Not only was it the wrong test, but it was a subtest to look at whether the mother had unequivocally told the father that she intended to remain in this country. If that is a proper test to be applied in settlement cases, which we don't accept in the first instance, but it would inevitably lead to applications for the parties to give oral evidence in the same way as takes place in consent and sometimes acquiescence cases. And for all the reasons highlighted in Re B by Lord Justice Moylan, that would be contrary to the objectives of convention and highly undesirable, and should be deplored. I don't invite the court to turn this up, but the point was emphasised by Baroness Hale also in the case of Re-M Zimbabwe at paragraphs 47, 48, that in the context of settlement cases, the court should not introduce additional elaboration with tests or checklists. So that's been re-emphasised by the House of Lords. If I can now turn to the judgment.
Well, you've passed over two cases, one of which the judge relied on as a summary of the law, namely Mr. Justice Williams's summary in AH and CD.
Yes.
Do you accept that that is an accurate summary of the principles?
We do. Even though the phrase holistic, I think seems to have appeared in the decisions of Mr. Justice Williams and Mr. Justice Harrison.
Well, that was
GB.
the second case
Yes,
I was
in
going to
G
ask
and B. We don't suggest that that's an inapt test for the court to adopt. in looking at the separate constituents of the gateway stage. And what Mr. Justice Williams emphasised in AHBCD, and this is in fact cited in the body of the judgment, and the reference at page 88 of F88, and it's paragraph 41(5), and this is the test that your Lordship is referring to. The point that was made earlier was that the underlying purpose of the exception is to enable the court, in furtherance of the welfare of the child, to decline a summary return, because imposing a summary return without a more detailed consideration of welfare might compound the harm caused by the original abduction by uprooting a child summarily from his by now familiar environment. And that is, we say, a highly significant factor in this case.
And then Mr. Justice Harrison, was that decided after? When was that decided? Is that after? No, it's before. It was before Mr. Allen's decision. Yes. But paragraphs 49 and 50 of Mr. Justice Harrison's judgment.
Just turn it.
I mentioned that, of course, because Mr. Justice Harrison is as known to be a specialist in this field, as is Mr. Justice Williams. So,
it's at tab 10.
tab 10, page 211 of the bundle. Do you take any issues with what he says there? So, for example, he says that you need to do more to establish settlement than you do to establish a change of habitual residence. I don't want to get down that rabbit hole.
Yes, yes.
He does say that, which perhaps indicates what's required. And then then in paragraph 50, he draws together some principles in rather similar way to Mr. Justice Williams.
Yes, I think we prefer the formulation of Mrs. Justice Bracewell in Re N, in saying that there was no definition of what long-term means, but rather the focus of the court should be whether the stay or presence of the child in this jurisdiction is transient. It may be said to be splitting hairs, but I think it is a different emphasis.
I raised the flag of permanent earlier,
Yes.
didn't I? And obviously, an issue in this case, or a factor in this case, is what is your client's prevarication about what her long-term plan was. And I suppose it might be an issue to the extent to which you'll take us to the evidence about this, but if it's right that she prevaricated to and fro about whether she was going to go back to Portugal, and if so, on what basis, to what extent her uncertainty, prevarication, is relevant to the child's requiring settlement in a new environment.
Well, firstly, we would submit that there is no requirement to be setting the bar too high for there to be a sub-test that the respondent has to establish that they intended to settle in this country permanently, because that moves the focus away from the child. And as we've already seen, there's examples where the parent may be considered to be unsettled, but the child is not, particularly where they're a fugitive and said to be on the run. There's even cases where one of the REC decisions, the parent did not have secure immigration status. but the tipping point came that the court decided because they were not at imminent risk of deportation, that did not mean that the child themselves could not be settled. And in this case, there were very powerful reasons why this was not a transient stay for the child, because the mother was coming home. She was coming back to her family. She had stable accommodation. She was picking up her life where it left off. And in looking at whether a young infant is able to achieve stability and security, the fact that their primary carer was saying that they were coming back here to heal and to recover from a toxic and dysfunctional relationship is again highly material, but these factors were all left out of the balance, even though they were strongly advocated on behalf of the mother at the trial.
May I just ask you, I don't want to take you out of turn, just want to be clear about, if I may, on the facts. I've referred to the evidence that your client prevaricated about going backwards and forwards to Portugal. And then obviously there's the agreement which she signed in October. But is it your, was it, as I understand it, it was your case before the judge that she had, by the time the proceedings started, reached a firm view. Is that right? And was
Absolutely.
Did the judge make a finding to that effect?
No, the judge made a general finding that the mother was not settled, but did not, there was no detail in respect of that finding as to the timing, as to whether it was in October 2024 or whether it was earlier or later. And the other feature of the judge's analysis is that the danger, as I've already said, in looking at only select messages that were exchanged between the parties in the absence of oral evidence, is that there was a multitude, there were many different interpretations the court could draw, but that should not happen in a vacuum, because of course that needs to be assessed in terms of what the mother was actually, in terms of her actual conduct. Her conduct was that she secured a long-term tenancy. She obtained a job. She enrolled her daughter in playgroups, in nursery. She was engaging with a therapist, and she was setting down all those ties. She was and she was establishing a close and firm relationship between the child and her maternal family. And there were tangible events, such as the mother said in her statement in July 2024, which is at the relevant time frame in respect to the discussions up to the signing of the agreement, the mother applied for legal aid in this jurisdiction to apply for a child arrangements order. So therefore, and I will take the court to certain messages that were sent by the mother, but the picture was not one way, as was suggested by the father and ultimately accepted by the court. In fact, when the parties embarked on mediation, the father had agreed to look at all options. And again, I'll take the court to these messages, but the father was actively contemplating moving to Wales himself. So it was a fallacy to say that it was a question of when rather than if the mother would move back to Portugal.
Again, I'm dipping into the judgment, so maybe I'll come back to that point when you get to the judgment.
So
I think that's where you were going now.
Yes, yes, and the material passage starts at paragraph 53. If I can make first point and looking at paragraph 54, as the judge already acknowledged in the earlier paragraph, settlement was a finding for the trial judge to make. It was not an issue for the CAFCAS officer, and therefore we don't accept that there was any imperative incumbent on the appellant to cross-examine the CAFCAS officer in this case, particularly where the CAFCAS officer had essentially left the question open and highlighted factors both ways for the court to take into account. But we don't accept that the CAFCAS officer's speculation as to what the child may have been told by her parents, and that's at paragraph 55 of the judgment, was the key consideration in this case. But it's at paragraph 56 where it becomes manifestly clear that the judge misdirected himself in the application of the legal principles.
Well, 56 is where I was just going to alight, just on the point I was mentioning earlier. What the judge said was there is no doubt that the mother had not communicated to the father an unequivocal intention permanent to reside in this jurisdiction would be until recently.
Yes.
2 points about that. First of all, do you accept that she hadn't? And secondly, it seems to me that by the time of the hearing, at least, she had.
We don't accept that, and the evidence before the court was that the mother had, by virtue of the fact that she refused to commit to a date over this lengthy period of time, was symptomatic of her unwillingness to return to Portugal. She was also imposing conditions upon her return, and the fact that the mother was in fact established a life for herself and the child all was part of the factual matrix.
Yes, but that's, forgive me, but that's not quite on the point. Is it? What the judge is saying is that until recently, she hadn't communicated to the father an unequivocal intention to permanently reside in this jurisdiction with the until recently.
Well, my lord, if I may, I say that's the secondary issue. The primary plank of this appeal is that that's entirely the wrong test in a settlement case. And in fact, where that emanates from is an entirely separate defence under Article 13 of consent and acquiescence. And the test in consent is, had the remaining parent clearly and unequivocally consented to the removal? In acquiescence, one of the exceptions to the defence is where the words or actions of the respondent clearly and unequivocally show and have led the applicant to believe, the respondent to believe, that the applicant would not assert the right to summary return. So this is language that is germane to a completely separate convention defences under Article 13, which is somehow crept into the test that the judges applied to Article 12. And we say, our primary position is that this is irrelevant to the gateway criteria as to whether the child is settled. And if the judge was going to embark upon that route, and if this court agrees that that sub-test should now be approached, we will now have settlement cases bogged down by all evidence.
I can understand why you might say it's not determinative evidence about what the mother's intentions to reside in the jurisdiction were. I understand that completely, and you made the point earlier about the distinction about what the parent was going to do and what actually happened. But I'm surprised surprised that you say it's irrelevant, because I'd have thought if facts were the other way round, you would be emphasising it a great deal. It would be relevant. It would be relevant, as I said, not necessarily determinative. So I'm just surprised that a submission is as strong as that. But that's your case, obviously. But I'd be interested in hearing what you have to say about that.
My lord, I take the point, but we say that it's not the primary consideration for the court, and it is very much a peripheral consideration.
Okay. Thank you.
But if one looks at the messages that this was introduced, this phraseology, in the skeleton argument that was submitted on behalf of the father.
Which particular phraseology?
Whether the mother communicated to the father an unequivocal intention permit to reside in the jurisdiction. And in fact, the judgment very closely follows the skeleton argument that was lodged on behalf of the father. And this is in your supplementary bundle. I do need to ask, cross-refer to this, in looking at the messages that the judge relied upon in paragraph 56 of his judgment. And the skeleton, the supplementary bundle. It's at page 28 of the supplementary bundle, paragraph 20A. And in the judgment of 56, if you could please have both the documents open, you can see that the judge relies upon the WhatsApp messages and emails cited by the father's legal team at paragraph 56B. And if we look at those messages, I would hope that they emphasise why this was an unhelpful question for the court to focus on. Because the messages start at the bottom of the skeleton at number 1. And we have two messages, the 5th of October and the 11th of October.
2022.
Yes. And one sees the immediate contradiction here. The child was 10 months old. So it reinforces the conflict between and the potential difference between the adult perspective and the child perspective. For a 10-month infant who was able to find a home and to establish a life in Wales, the fact that her mother is having back and forth conversations with the father as to how long they're going to stay in Wales and whether they're going to return to Portugal, on the premise that the mother is saying that she needs more time to heal, is neither here nor there.
So you're saying that what the mother was saying and thinking about her future intentions is not relevant, or
well, we say it's tangential to the issue as to whether on the ground the child was putting down roots and establishing a home here. And even looking at these
tangential, you say?
Yes. And even, because if one looks at the messages that were relied upon, there's then a jump of 17 months from October 2022 to March 2024. And the question that the court should have been asking is what happened to the child in those intervening 17 months. By June 2023, she had moved into her current home, which is the longest home that she's ever had in her life. That is the cornerstone of stability for her. And she had, as we've already said, established a solid network and community and a social family environment in Wales. And then if we look at the messages that are cited at Roman numeral 3 onwards, the mother's not saying, I'm definitely coming back to Portugal. She's saying, on a conditional basis, she'll come back when she can support us.
I
and
will
find
move back to Portugal.
when I can support us.
Well, no, sorry, forgive me. Roman 5, I will move back to Portugal.
Well,
Roman
I'm
6, basically, I'm agreeing to move to January.
Well, I'm looking at March 2024. And, but this, and the first time that a date is mentioned in these messages is at Roman numeral 6, where on the 4th of June 2024, the mother said she was agreeing to move back in January 2025, which was over 2 years after the child moving to Wales. And the messages, if I can now redress the other side of the balance, which was not looked at by the court.
Well, before you do that, Ms. Guha, may I just... Your point is, as I understand it, is that whatever the mother was saying didn't prevent the child becoming settled while she was saying it. In the months and years while the mother was making these comments in messages, the child was becoming settled.
Yes.
As a matter of fact. Yeah?
In the context where the mother said, essentially, this was a controlling relationship with the dynamic
Yes,
of power was imbalanced, and I was overwhelmed.
By the time of the proceedings, it seems, the mother was saying to the father that she intended to reside in this country.
Yeah,
Because Mr. Gupta says so in his skeleton.
yes, and the concrete step.
Very recently she said it.
Yes,
So by the time of the proceedings, there was a permanent intention, wasn't
and there's 3 significant dates in chronology. 2. Firstly, at the end of November 24, when the mother said to the father in person, I'm not moving back to Portugal. And the second,
Sorry, the date was what?
it was the 30th of November,
Yeah.
2024. And this, objectively, the second concrete event was the mother issuing the proceedings in the Swansea Family Court in early 2025, seeking a child arrangements order to secure the child living in this jurisdiction. And what the judge did not do, as I said, was look at this case in a balanced way, because he did not look at the... we say that it was a flawed approach to simply cherry pick some of the messages in a lengthy chronology, when there were, of course, messages both ways, and there was no cross-examination or testing of this evidence for the judge to establish his own evaluation as to where the reality lay. Was this a mother who had, in fact, consistently told the father and led him to believe that she'd be moving back to Portugal, or was it, in fact, a far more mixed picture where, at times, it was fairly obvious that the mother was extremely reluctant, if not unwilling, to move back to Portugal? For example, I'm going to take them in chronological order. In the interest of time, I may just give the court the references. But in a supplementary bundle at 108, on the 18th of January 2023, the father expressly said that in listing the possibilities, the options, firstly, father is going to live in Wales near the child. or secondly, the mother returns to Portugal. So this was within 4 months of the removal. Page 104, on the 20th of January
Sorry, give me that reference again, the first one.
108
Page supplemental bundle.
in the supplementary bundle. These are all in the supplementary bundle. On the 20th of January 2024, 104, the father says, I know that in your own narrative, you didn't have any other solution than to move to Wales, but in this present things can change. I respected that I just need more time here in Wales to heal, but the temporary, now as confirmed by you, can be forever. This, for me, is the biggest issue. And in January 24, he was saying, I am available to live near you, even if I really don't connect with a place, as you know. So even in January 2024, the father had not taken the option of him moving to Wales off the table. Further, refer the court to 174. The mother's saying on the 16th of March 24 that she would only come back when she could support her and her child and find a place, and then we can make a home. And the reason why this is so critical in this case is that the mother said she needed to remain in her home environment, not only to recover from the relationship, but also to establish an independent life for her to raise her daughter. And the fear that's been pervasive for the mother, that if she returns to Portugal, this would be to no home, no means of working, no means of support, in circumstances where she again would be dependent on the person she accuses of being her abuser and of being controlling of her. And then at 184, the father himself said that at some point you want to go back living in Portugal and bringing her up in Portugal, and talked about the inconsistencies in what she had said. And on the 23rd of December 2024 at 2:15, the mother emphasised that she needed legal safety from the UK, that she'd be able to return home to the UK for 6 months. And in
Just so that I've got it clear in my mind, you've taken us through all these other, and I'm sure there are many more, messages and reiterations of the position. Your position, however, is that one shouldn't get into these things, as I understand it, in too much detail. Otherwise, one is cherry-picking one way or the other, and it's not appropriate for there to be oral evidence testing.
yes,
All of these things. So us delving into more and more messages is not really very helpful, is it? Despite the fact that you accepted when Lord Justice Birss said that rather than irrelevant, what was your position? And you said you accepted that it wasn't a primary consideration exactly what the intention of the parent had been. So what are we to make of all this deep dive into all these messages? Where does it really come out?
I think that's our secondary position. The primary position is that it's not the proper test or criteria that the court should have applied. Our secondary position is that the judge only cherry-picked some of the messages and did not look at the overall landscape of what was happening during that period.
And what therefore, if you take into account all these other messages, to which you've referred us, are you saying that the conclusion the judge should have reached in relation to the messages?
We'd say the overall impression that the judge was entitled to form was that during those 2.5 years, there had been ongoing discussions, negotiations between the parties, back and forth as to the long-term situation. And at times, the mother had said that she would move back to Portugal, but ultimately she did not back that up with any concrete action. And even when she signed the agreement in October 2024, she reneged from that within a matter of weeks.
How far is that materially different from what the judge said? The judge said that she didn't give a clear, unequivocal communication to the father that she wasn't coming back until recently.
Well, the difference is that the judge relied upon that to deduce that the child was not settled. And we say that that does not follow, because what the primary considerations for the court was whether the child herself would have been exposed to any uncertainty emanating from those adult discussions. That was why it's moving to a subtest. I've already made the point that ultimately, where a child was visited by their father on such a regular basis, 33 times, and was able to maintain the strength of that relationship, that would have encouraged, not discouraged, her ability to settle. And the only aspect where the judge relied upon that, he did not feed that in at all at the gateway stage in the analysis of his judgment. It only in fact features when looking at discretion.
Sorry, have I got this submission right? You're saying that the fact that the child was having very regular contact with the father added to the settlement.
Absolutely. At the gateway stage, it was a very strong feature of the mother's case. But the judge didn't rely upon this at all until the discretionary stage, and that's at paragraph 86 of his judgment. And it's slightly contradictory, because he relied upon the discretionary stage to say that this child will to a great extent settle and adapt to changing circumstances, provided she's in her mother's care, and bright and resilient and bilingual. And he goes on to cite from the Kafkas report. Well, if that was all true at this point of time, why was it not true from September 2022 onwards? And that is the contradiction in the judge's analysis. And just to re-emphasise, the other headlines are: there was no evidence of the child being emotionally distressed or unable to meet her milestones. In fact, all the evidence was to the contrary. She appeared to be flourishing, and the detail of the mother's statement, which I do ask the courts to look at in due regard, if I can just find the reference.
Her mother's principal statement is at 58 in the supplement.
It's pages 73 to 78. I'm not going to take the court to that in the interest of time. You may wish to look at that now to skim read it. But as I've already outlined, in 5 detailed pages, the mother paints a vivid picture of how this child had embedded into life in Wales. the judge only refers to the father skeleton argument and the snapshot in the Kafkas report. For example, the Kafkas referred to a strong friendship with one particular child, and that the significance of that is lost in the judgment, because it appears that it's a fairly limited qualitative existence that this child had. He did not cross-refer back to the mother's statement, where she goes, she explains a very wide network of friends. She gives the names of all of them. She talks about as though the paternal grandparents and her brother, who has 3 children, and none of those elements in respect to the relationships that this child has formed and benefited from in being close proximity to her family, and they have obviously provided important support to her mother. None of that feeded into his analysis, and we say those were the primary factors that the court should have been looking at, in the same way that the judges did in the 2 Re-C cases, rather than looking at what the mother intended when she sent those messages in October 2022 and in 2024. And even if one looks at the father's case at its highest, when the mother was saying that she would return to Portugal in 2024, what was the reality that translated to for this child? They went to Portugal for a few weeks in the autumn of 2024, and the mother rented a cabin, and the child stayed there for a matter of days. But how the judge evaluated that was to say this child has equivalent homes in Wales and in Portugal, and that simply does not stand up to scrutiny, because she has a permanent stable home in Wales. She's been living there now for 3 years, and the only property that the mother had in Portugal was one where she had stayed for a matter of days. And in respect of a home with her father, she had only had a handful of overnight stays with her father in Portugal. So, from a qualitative perspective, a distinction should have been drawn between the home that the child has in this jurisdiction, which she clearly regarded as a primary base. Because from her angle, what a small child would be concerned about is where her bedroom is, where her primary carer is, where her friends are, where her nursery is, whether she's seeing her father, and in respect of the forest school she goes to, and those were as I said already, the magnetic factors which governed whether this child was settled. If I can just go through the judge's analysis. Paragraph 57 and paragraph 58, the judge mentions whether the child would have been told by her parents that she was returning to Portugal. The judge ultimately decided that he did not need to resolve whether the father's contention that the mother had said this to her was true or not, and relied upon this to say that the child would have been feeling in limbo. But our submission is that this was an artificial analysis when one looks at the age of this child, and it is highly artificial to say that the subject child would have been cognizant, would have had a full understanding of negotiations that were taking place between her parents, because that's...
Well, obviously she wouldn't have a full understanding. I think the judge
But
He talks about not the child not having on any view, a clear and consistent message.
But this was the evidence that the judge relied upon to say at paragraph 58, I agree that the child will therefore feel in limbo. And this was a material factor that led him to reject the defence of settlement.
Leaving aside the characterisation of feeling in limbo, it's not clear to me why the judge wasn't entitled to reach the conclusion that's in the beginning of that sentence, that either way, the child has not received a clear and consistent message that this country is or will be her permanent home. I don't understand. Are you submitting that that wasn't open to the judge to make that finding, or are you, or what? I get that the limbo is a maybe a tendentious way of putting it, but before we get to that, can I just understand what the position is on the first part?
Well, there was highly tenuous evidence before the court on this issue. And again, the judge did not hear any oral evidence. So we don't accept that the judge made sustainable findings as to what the message that this child received. And again, we say that falls far down the ladder of priority in this case.
The child can't have received a clear and consistent message that she was going to stay in this country, because that wasn't the clear and consistent view of anybody. As I understand your principal point, that's not the question.
Well, there are many different options in this case. Either the child was given a clear message that she was staying. Secondly, the issue was not ventured in conversation directly with the child at all, as one would expect with a parent and a young child. Thirdly, she may have been given messages either way, but this all had to be assessed in the context of the child's understanding. As a 1-year-old, as a 2-year-old, as a 3-year-old, she had 2 of her birthday parties in Wales. The father travelled to this jurisdiction to attend one of them. She also had Christmas celebrations in this country with her family. Those were that was a far more important consideration for whether, from the child's perspective, whether she thought she had a home here and whether she was going to be staying here. And similarly, the judge's analysis at paragraph 61.
Before you go on to that, at 59, the judge accepts their father's evidence that the child said, when am I going to Portugal? Presumably that has to be read into his conclusion at 58 about limbo, perhaps.
But yes.
What do you say about that?
Well, the difficulty with that is, again, it can have 2 meanings. Did the child mean that she was going to Portugal for a visit? Or did she mean, when am I going to Portugal? It does not say, when am I going back to Portugal to live?
No. And so, basically, it seems to me that your underlying message, or one of them, is the judge couldn't have reached any conclusions because all he had was a potpourri of WhatsApp messages which weren't subject to cross-examination in any way. In similar ways, he had evidence, tidbits of evidence about the child. So are you saying, actually, that he ought to have cast aside all this evidence? I'm confused because we went to all these messages, etc. Was he not entitled to take a view about all of this? First, my first question to you. Second question is, if he was, isn't your complaint that actually he didn't evaluate this evidence in the light of the age of the child and the other factors?
Yes.
Isn't that really what you're saying?
Your client's evidence.
Yes, that is. That is.
That's it.
Yes.
Yeah.
But
As I understand your case.
Yes.
The lady says he focused too much on discretion.
Yes.
What message was the child getting? She wasn't getting a clear message. Therefore, she can't have become settled. When in fact, he should have taken into account all the evidence you've alluded to
Yes,
and asked us to look at, which showed that she was getting consent.
which would have, and if you'd looked at all the broad evidence as to the child's reality in respect of the life she established in Wales, as described, paragraph 73 onwards of the mother's statement, that would have been the answer to a straightforward examination of the gateway criteria as to whether the child was physically, emotionally, psychologically settled. And this was an issue that should not have dominated the judge's analysis in the way that it did.
Okay, if we're going back to the judgment, are there other aspects you want to show us where you say the judge went wrong?
Yes, there are. That was the main consideration.
Yep.
As I've already touched upon in earlier submissions, paragraph 63.
Well, you've gone past 61.
61 we've just dealt with.
60, do you, as I understand your case, is that far from the lack of settlement being compounded by the contact she was having with the father, it was in fact supported.
Exactly. And we don't accept the conclusion drawn at paragraph 61 that as a 3-year-old, or even as a 2-year-old, that the child was not able to distinguish one country to be her home and one where she travels for holiday. One of the statistics that was put forward by the father was that the child was said to have lived in Portugal for 39% of her life. In fact, there were 33 months between September 22 and June 25, the date of the trial. For the 33 of those months, the child had spent 27 living in Wales, which was something like 72% of her life. But the reason why that is important is because the judge, as I've already alluded to, the judge tried to equate the quality of the home that she had in this country and in Portugal. And we say there is no doubt that the child had a concept of where her main home base, her primary home base was in this jurisdiction. As in, what was the bedroom that she slept in? Where were the majority of her belongings? Where did she return to after every visit to Wales?
Portugal.
Sorry, yes, Portugal.
You were going to paragraph 63, I think.
But again, if I can forgive for it, 62 is where the judge deals with the points, as it were, on your side, your client's side. But you say that is insufficient.
Yes,
and
it's
taken what Mr. Gupta said.
but it's almost dealt with in passing, and the court had recorded at paragraph 50 the summary of the mother's case in respect of settlement, but the judge did not then refer back to that long list of factors, paragraph 50 of the judgment, in his analysis, but all we have are these 2 lines at the end of paragraph 62.
Sorry, you're kind of 63. We've interrupted you. I've interrupted you a lot. You want to come to 63.
So paragraph 63 indicates that the court, that the judge directed himself as to whether the mother herself had considered remaining in this jurisdiction to be a long-term stable arrangement. And we say drew the unsafe assumption that the mother had not, on the totality of the evidence, decided to establish a home here to all intents and purposes, despite the ongoing negotiations. And the judge went on later in the judgment to make a finding that she was not settled in this jurisdiction, which, as we've already referred to, Mrs. Justice Bracewell said that that wasn't a relevant consideration.
What do you say about the last two lines of
Yes.
63?
Well, that is contrary to the jurisprudence that I've already taken the court to, because I think we've said the paradigm example is concealment and subterfuge cases. That it could be argued that the parent who is on the run is not themselves settled, but in two of the leading cases, we've seen that nonetheless the court has found that the child themselves are settled. So one does not automatically follow from the other.
The last sentence is wrong. You say, do you?
Well, we don't accept that the mother herself did not feel settled. We say that's, again, not the right test, but secondly, we don't accept the mother herself did not feel settled or anchored returning to her home environment in Wales. So we say that that was an irrational finding to make.
But even if the judge was entitled to find on the evidence that the mother wasn't settled,
Is it your case that that didn't mean that B could not become?
Yes. Yes. I think I've already dealt with the October agreement. I'm sorry, I just need to return back to my notes. And looking, sorry, I should have said, looking at paragraph 63 and 64 as to whether the mother considered this to be a stable arrangement. There was no evidence that the mother had communicated to the father, I am unhappy in Wales, I'm not able to make a life here, and I cannot give our child the upbringing that she needs. So that very much counters the conclusion that the judge came to as well. In fact, everything she said was the contrary, which is, my circumstances are far more improved in this jurisdiction. I'm in a much better place to look after a daughter, and I'm worried about the insecurity of returning to Portugal. So, the judge did not enter into that comparative analysis. I've already dealt with the October agreement, and that was dealt with in the mother's statement as to why she, at paragraph 63 and 69, she emphasised the fact that she did not have legal advice and that she had succumbed to pressure from the father in signing that agreement. And of course, it was signed in October 2024, 2 years after the child had moved and set up home with her father, set up home with her mother in Wales. And in looking at the mother's case, the court did not factor in looking at settlement, how the mother's situation, she says, had greatly improved. Her emotional state had improved. She had access to a strong and extensive support network, and all of that would be taken away if she returned to Portugal. think the point that we also would wish to emphasise is that the danger of paying too much scrutiny to the issue of the parental discussions is that not only does this detract from the situation of the child, which is the objective of the defence, but when one looks at the primary aim of the convention, it is that parents, particularly such as the father in this case where he had access to legal advice, would be aware of the imperative to issue an application within 1 year. So one has to also examine that in that context. And this may, it leads on to the comments made by the judge about the policy issues in respect of parties engaging into mediation, but I'll turn to that in due course when looking at the discretion stage. But
I'm sorry, so your point is that in relation to all of this, one should take into account the fact that the father did not make a speedy application.
Yes, yes. And of course, there were shades of grey when looking at the mother's position, and one had to bear in mind that the mother said that she was unable to assert her views with the father. So that was a factor that was not adequately taken into account.
Okay.
Moving on to the judge's approach to discretion, the legal framework is very clear in the House of Lords decision, Riem in Zimbabwe, that discretion is at large and that the court can take into account welfare considerations. But even though this was specifically advanced at the trial, there's no real consideration within the judgment as to why the Portuguese courts were better placed to determine the welfare disputes than the Welsh courts. And of course, one has to bear in mind that the Welsh court had already been seized in this case, and the proceedings have been stayed at the assumption of the Hague Convention proceedings, but nothing has to date been issued in a Portuguese court. In Re-M at paragraph 461, the same point was made as in the explanatory report, that return should only happen after the examination of the merits of the welfare dispute, where a child was settled.
Where was that from?
It's the House of Lords decision,
Riem.
Riem,
Sorry.
paragraph 461.
You must mean page 461, do you? Is it paragraph?
No, yes, page 400.
Which paragraph number, Lady Hurst? 47.
Yes, that's the top of the page, paragraph 461. And in fact, there's a passage that refers to the point, the submission I just made at the bottom, 460, where Baroness Hale emphasised that Article 12 tries to draw a principal line between the claimant who brings proceedings in time and should not be prejudiced by delays in the system, and the claimant who does not, who should not succeed under the convention once the child has become settled. And case that I would ask the court to look at is Re O, where the Court of Appeal, and that is at tab 6, page 91, paragraph 14 of the judgment. And this was a case where the judge at first instance made a finding that the children were settled, but nonetheless went on to exercise his discretion to return the children, in fact in this case to a third country in America. The Court of Appeal agreed that the judge had erred in law and set aside the order for return and substituted its own decision that discretion should be exercised to refuse the application for summary return. And I'd invite the court to read paragraph 14 and paragraphs 24 and 25. And the point that's emphasised is that the court must not adopt a generalised approach that, for example, younger children will adapt more easily, and that one must always refer it back to the characteristics of the individual child in this case. And we say the judge failed to do that because, again, is overlap with the points that have already been made, but rather than referring to the body of evidence about the quality of the life that the child had established in this jurisdiction and what the impact of an upheaval from that environment, from that social and family environment would be, the judge took a more broad brush approach in saying if the child is dependent on a mother, there's no reason why she should not re-assimilate into life in Portugal, even though she's been away from there. She has not been living in that jurisdiction for 3 years. And at paragraph 49 of the judgment, the Court of Appeal agreed in that case that the mother who had said that the father in that case had behaved in an immoderate and underhand way was an important factor when looking at the discretion if the parent was going to be removed from their support network and returned to the comparative isolation of the home country, and made the obvious point, which was not taken into account when the judge looked at discretion here, that the mother's sense of security is bound to make a vital contribution to her ability to look after the child. And this, of course, was a case where the father had expressly been asked for an undertaking to agree that the mother and child could return to Wales on visits if they relocated back to Portugal, and the father emphatically agreed that position and said he would not agree to any visits to Wales for a period of 1 year. And in a case where this is a dual heritage child, where on one hand the judge was saying that she had 2 homes and could seamlessly move back to Portugal, the highly damaging impact on not only the child but also of her mother, of being cut off from their home and life in Wales, was not adequately weighed into the discretion in this case. And in the judge's examination of the impact on the mother's mental health at paragraph 83, we say that the judge approached this in the context of whether the Article 13b threshold was met, rather than looking at, through the prism of welfare, as to where a mother suffers from anxiety and is experiencing symptoms of depression, is saying in terms to the expert that she sees moving back to Portugal as a threat, that she would feel insecure, that she would not be able to revert to her typical coping mechanisms of returning home to Wales, of taking advantage of a support network. The judge did not take that into context, and in fact said at paragraph 83, there is no clear evidence that it would have such a detrimental impact on X, and in particular the mother's ability to parent her. And we don't say that that was a sustainable interpretation of the psychiatric evidence in this case. And if I could refer the court briefly to that in the supplementary bundle. And relevant reference. Apologise, court, just bear with me. It's at 303. Well, it's 301 to 303. Firstly, 301 deals with what the mother was saying in respect of the limitations on her coping mechanisms, how she experienced this to be a threat.
Which paragraph are you reading?
That's at paragraph 21 on page 301. And she described how the change in circumstances, separation from a current lifestyle and support network, in paragraph 22, would impact on her well-being, in particular when she was experiencing symptoms of depression. The mother said that this adjustment period of going back to Portugal would directly impact upon the child, as this would affect her own stability and presence, as in her availability to the child. So that was not factored into account. And then the actual assessment by the psychiatrist is at page 303, at paragraphs 24 and 25. So in summary, the psychiatrist identifies the various stressors that would come into play that would be detrimental to the mother's emotional, mental state and well-being, and says in terms that at paragraph 25, he was not in a position to predict how this would impact upon the mother. But he did go on to say it would be reasonable to consider that this would have a cumulative impact on her, and made the point at the bottom of 303 that enduring significant stress does indicate some degree of risk that a child in the care of the parent may be exposed to instability, change of consistency, and whether the parent is able to engage, focus on the child's needs, and exposure to unstable circumstances, such as housing and finances. And of course, the evidence in this case is that the mother's residence permit is lapsed. She does not have secure immigration status. During the currency of any immigration application, the mother has no recourse to benefits. She has no right to work. And these social stressors and her inability to lead an independent life is recognised by the expert to have rebound on her mental state. So looking at those aspects of the report, which were not challenged, and of course the court did not hear evidence from the expert, it was not a sustainable conclusion at paragraph 83 that there is no clear evidence that would have such a detrimental impact on B, in particular, M's ability to parent her. And the judge's analysis was simply to say, compared to with the prospect of not spending regular time with father, that pales into comparison. But of course, the difficulty with that proposition is that there was no sound evidence before the court that the father would dramatically change his behaviour from the previous few years of no longer coming to visit his child on a frequent basis. The mother's evidence at the same section, paragraph 77, I believe, said that the father was able to work remotely, and that was what facilitated his regular stays in Wales. The father had not said his occupation or his means of income had changed in any way, and it was a self-serving statement that the father had put forward in the case that he would not be able to travel as frequently, and that we say that should have been approached in a more circumspect fashion by the trial judge. It may be, if I now deal with paragraph 84, which is the what the judge said was the policy point in respect of mediation. We can take this relatively shortly as the judge's analysis that a applicant should not be penalised by virtue of the fact that they entered into mediation is not consistent with the dicta that we've just seen of Baroness Hale in Riem, that a distinction has to be drawn between a parent who brings the application in time and one does not, because for all the reasons that we've already explored, the consequence is that the child's social family environment shifts from the country of habitual residence to the new country. Therefore, the impetus for a swift return dissipates. And also the reference to Part 3 of the Family Procedure Rules was enacted in this case because that applies to domestic proceedings which are already afoot in this jurisdiction, and it has no real relevance to what happens pre-proceedings in International Hague Convention cases. And we've already made the point that the father, of course, had access to legal advice, and he never asserted that he was unaware of his Hague Convention remedy. And this, of course, is not cases where one should engage in what's been described as a comparative analysis of moral blameworthiness, because the primary focus is what the impact on the child is. And in the judge's analysis, he did not sufficiently engage with the mother's case and simply approached the factors that had been advanced by the father in the skeleton argument as to why the discretion should be exercised to order a summary return. If one stands back to look at this case, the child is now 3 years, 9 months old. She has been living in Wales for 3 years old, for 3 years, for the vast majority of her life. And for the judge to come to the fairly perfunctory view that notwithstanding all the obstacles, difficulties that the mother would face, the scale of the upheaval for her and for the child, for him to effectively disregard that evidence and say that the child could easily adapt to a move was a rationally insupportable conclusion. I will try to deal with the remaining points swiftly, but if I can first deal with ground 3 in respect to the immigration expert. This is a fairly short point. It's been addressed in our skeleton argument at paragraphs 29, so I'm not going to reiterate those submissions, but the fundamental case is that there was no certainty that the mother would be granted immigration status in this case. And that is not what the immigration expert said. And he was clear that this was a discretionary exercise. In the written report, he did not venture an opinion as to the prospects of success. In fact, he did not have much of the primary material to inform that decision. For example, he had not been able to access the actual residence permit that the mother had. He did not know the basis of which he'd applied for it, whether it was a permanent residence, and so forth. But the secondary aspect of his opinion was that this was going to lead the mother into a protracted period of uncertainty. And he accepted in the addendum questions and in his oral evidence that it could take up to 3 years for an immigration application that could be factored in. And there were 2 routes. Firstly, that the mother could have renewed her existing permit, but that now has lapsed. It lapsed in June of this year, so that does not appear to be a realistic route. And of course, the mother faced the difficulties that she did not have a good explanation for her absence, because it was of her own volition that she had left Portugal and has spent the last 3 years living in Wales. The second route was to apply on the basis of the child, but the
You mean the
difficult
child being in Portugal?
being a Portuguese citizen.
Citizen.
But even with that route, the mother would still have to fulfil the residence requirement. And so the difficulty that arises with that is that the mother had said, and there was no reason for the court not to rely upon this, was that the cabin that she had secured in November 2024 was an illegal dwelling. It had no formal tenancy agreement. It had no independent postal address. And the expert accepted in his oral evidence that the requirements of a legal tenancy. And what is evident at page 6 of the agreed note of evidence was that the expert,
Sorry, page
6 of the note of evidence, was that the expert agreed in response to a question posed by myself that the mother would have to establish a 6-month period of continuous residence immediately prior to the date of the application. And he said that would be very difficult to waive.
Where is that on the page 6? Sorry, forgive me.
Apologise, I just have to access the document.
Oh, there we are. 2/3 the way down.
Yes. So it's this passage, that's the standard criteria is 6 months continuous residence. The expert agreed and was then asked the follow-up question of whether there was good reason to ask the authorities to waive that criteria, and the answer was no. And then court's been taken to what the judge, what the expert said in respect of the prospects of success. And that is at page 8 of the transcript, 2/3 of the way down. But it's, one could say, a fairly nebulous answer.
Where are we looking?
It 2/3 of the way down, JPC, optimistic,
Yes, got it.
difficult.
Question of evaluation, etc.
Yes, yes. What the expert did not say was, I think it's highly likely, or there's a 90%, 95% prospect that the mother will be granted an immigration status. And one has to read that in conjunction with the earlier answer, that there were some fundamental criteria that the mother was not able to fulfill in respect of residence. And also, at page 7 of the note, 5 lines from the bottom, the expert agreed that if the mother herself left Portugal during the currency of any application, she may not be readmitted entry. And that is a highly critical factor for this mother, who is so highly dependent upon her support network in this jurisdiction. My Lord, I am going to move to Article 13B now. I'm afraid I may not finish by 1, but I'm going to spend a shorter period of time, much shorter period of time on this.
Excuse me a moment. We have your written submissions on Article 13B. Perhaps you'll just confine yourself to anything additional you'd like to add.
If I may, can I just make the headline points?
Yep.
There may be some repetition, of course. Firstly, we say the court was not in a position to confidently discount the abuse allegations.
You mean that's the recent allegation?
Either of them. The abuse allegations against the father and also the sexual abuse allegations.
Involving the child?
Yes. And what the note of the evidence in fact shows is that the judge had told both the parties at page 2 of the note, in discussion with myself and Mr. Gupta, that the approach that he was going to take was that he would have to take them into account unless he could confidently discount them. And halfway down the page, the judge asked me how these allegations were relevant, the Article 13b defence, and I said yes, and to the issue of discretion. The reason why it's relevant to discretion, of course, is because the appropriate forum for investigation into the truth of those allegations is the place where they are alleged to have occurred, i.e. Wales, not Portugal. And this would, of course, be an important component of any welfare dispute. And the judge reiterated at the bottom of page 2 to Mr. Gupta, you've heard me say that I take the allegations at its highest until incredible, and then decide that they're across the Article 13b threshold, and then I determine whether they're protective measures. And the judge decided to admit the evidence where the mother had set out her primary case in respect of what she had been told by the child. And I would ask the court to refer to the skeleton argument that was lodged on behalf of the mother at the trial, which very clearly spelt out the cumulative elements of the defence, and it's a paragraph 34, page 18 of the supplementary bundle. And the different components were not only the abuse allegations, the two separate categories of abuse allegations, but the immigration position, the impact on the mother's mental health, well-being, losing her support network, and losing her access to her therapist. And the headlines is that we say that the judge was not entitled to confidently discount the abuse allegations. He did not, even though he said at paragraph 103 that he must consider the cumulative impact of harm. In fact, at paragraph 105, he looks at the abuse allegations against the father in isolation and says it doesn't meet the threshold, and doesn't look at it on a cumulative basis. And in any event, this was not a conclusion that he was entitled to reach. The mother said in a statement at paragraph 34 to the CAFCAS officer at 261 of the supplementary bundle that the abuse had escalated since she had moved to Wales. The CAFCAS officer did not say, in her professional opinion as a social worker, that this was situational abuse and was no longer subsisting. She said at paragraph 55, they must be considered at its most serious. And I can give that reference to the CAFCAS report if the court needs it, but it's paragraph 55 on page 267. And we don't accept that the reasons relied upon the judge at paragraph 106 were legitimate reasons that could lead to him to say that the allegations should not be taken into account, because what the mother did or did not say in litigation issued in early 2025 on pro forma forms, that was not the key evidence in this case. And this clearly fell foul of the guidance of the Supreme Court in Re E. Essentially, what the court had to do was to look at whether this was a situation that the child should be expected to tolerate on a return. And the court was incumbent on the court to look at the concrete situation on the ground for the child. And for all the reasons that have already been advanced, we say cumulatively, where a child has established a stable and settled life in this jurisdiction for 3 years, she should not be exposed to that upheaval, and it would not be tolerable. There was no consideration as to what would happen if the mother's immigration application was refused and if it was delayed for 3 years or longer. And in the decision of Lord Justice Moylan at Re B, in respect of oral evidence, he flagged at paragraphs 89 onwards that in looking at the question of immigration status, the court does need to think whether that could lead to separation from the child from their mother and could lead to a mother not being able to meet their basic needs. And that was very much part and parcel of the mother's case in respect of the precarious situation regarding her immigration position. And moving to the protective measures, that was dealt with in the skeleton argument, but the fundamental point is this. As stated by Professor Perez-Vera, there is a distinction between settlement and other cases. There's no duty that a return must take place forthwith. Therefore, there was no rational reason why the court should not have followed the clear guidance in requiring an order to be registered in Portugal prior to a return to ensure the efficacy of the protective measures and to ensure that they were enforceable. And this was touched upon by Mr. Justice MacDonald in H&O, and it's page 444 of the authorities bundle, and I'd ask the court to consider paragraph 66, Roman numeral 3, as to why, even with a 1996 signatory state, it should not be assumed that undertakings are treated as measures that can be automatically enforceable under the 1996 convention. And that was also a point made by Baroness Hale in Re E, but that's cited in our skeleton argument. And there is a debate as to whether, in particular, for example, measures for financial provision and maintenance undertakings in that regard can be treated to be measures because they don't fall within the classification of Article 4 of the 1996 Hague Convention. The court did not have satisfactory evidence about any of these matters. A proportionate approach was taken. We did not invite the court to adjourn the trial to get an expert report, but we said, in the context of a case where a child has been living here for nearly 3 years, to follow the principles and the case law, the order must be registered to remove any doubt as to whether those protective measures which effectively ameliorate the Article 13b risk would be effective. And also, there's also a debate whether non-molestation orders and similar orders could also be treated as measures of the 96 Hague Convention. The main complaint of the mother in respect of the undertakings that were accepted by the judge is that he did not accede to the mother's case that she required independent accommodation. The request has been renewed that the father forward the funds he was going to pay his cousin to the mother to secure independent accommodation. He's refused that. But the consequences for this mother, where she says she perceives returning to Portugal as a threat, is that she has not been allowed to secure an independent home in a place where she wants to live, where she is going to be beholden to the father's family, and she, in her eyes, the father. And she has no proper, the court did not have any proper particular property particulars or any detailed evidence about this house or property. And in those circumstances, we say that the judge's determination that there were adequate protective measures in this case was flawed and should be set aside. May I just turn my back before I conclude? So in conclusion, we would invite the court to set aside the order for summary return and to substitute its own decision that the child is settled in this jurisdiction at the relevant date and exercise its discretion to refuse an order for summary return.
Thank you very much, Ms. Guichard, and absolutely bang on time. Thank you. We'll rise now at 2 o'clock.
Well,